What I'm going to cover is the sort of series of responses from the Grenfell Tower disaster in 2017. A series of responses have been delivered, but broadly, 14th June 2017, a malfunctioning fridge freezer started a fire on the 4th floor of Grenfell Tower, the block of flats in North Kensington. The flames spread beyond the flat where it developed up the external part of the block, with the resulting loss of life by the end of it all of 72 residents. A series of industry and government level inquiries were undertaken, including the major review undertaken by Dame Judith Hackett. And while the inevitable focus was on the sort of structures of the Grenfell Tower type, the conclusions of the inquiries were broadly that the building safety system in the UK in general was not fit for purpose. The conclusions included the need for there to be a more effective regulatory and accountability framework for greater oversight of the building sector, to introduce clearer standards and guidance, to give greater powers to residents in regards to the management of risk, new routes being introduced also for seeking remedies for defective or inadequate construction. And there was overall a need to drive a culture change for a more responsible construction sector, from design to construction to management and refurbishment. In terms of the immediate responses, one of the first was for government to say, well, buildings above 18 meters, which is really just mostly down to how high fire engine ladders can actually reach, where those buildings were clad with aluminium composite cladding materials, ACM materials, which were not compliant with the building regulations, and that cladding need to be removed. That caused not a small amount of concern to residents of such blocks and also their mortgage holders. The RSCS jumped in with the EWS certification system, which was an industry response really to try and give some sort of degree of comfort to occupants and mortgage lenders about the structures that they were living in. The Fire Safety Act has just been introduced, implementing the recommendations of Sir Martin Moore-Bick in his report, the Grenfell Tower Inquiry. The Act applies to all multi-occupied residential buildings, not just dependent upon height, and requires, amongst other things, the appointment of a responsible person for fire safety, giving them a duty to undertake assessments and to manage risk. Beyond that, the government announced the funding for the removal of unsafe cladding works materials. The total of that fund is currently sitting at 5.1 billion. This though only applies to works on buildings taller than 18 meters. For buildings between 11 meters and 18 meters, there is the proposal for a loan scheme. However, the Ministry of Housing, as was now called the Department for Levelling Up under Michael Gove, in its 12th August 21 data release, identified that there could be as many as 473 ACM-clad buildings which were not building regulation compliant. And at the same time, a separate Ministry of Housing committee came to the conclusion that the total cost of remedial works could be as much as 15 billion, well in excess of the government funding. But in terms of where all that money is to come from, the Chancellor recently announced in the budget just gone the 4% property developer tax, which will come into effect in 2022, expected to raise £1 billion over 5 years, which is part of how the industry pays for the problem that it's produced. What's also though become apparent as investigation work has been undertaken is that there is a lot more than fire safety issues that many existing multi-occupied buildings face. Other issues coming to light in terms of defective fire stopping systems, smoke ventilation systems. So there's an awful lot of concern for those who are occupying such buildings. Many existing residents are currently without much of a solution. But the Building Safety Bill is about how to address the future. Next slide, please, Tom. Most of what's involved will apply only in England because building regulation is devolved. Certain elements, though, will have a wider impact. The first version of the bill in July 20 was criticised for being too slim. A more detailed version of 208 pages with a very long guidance note was produced in 2021. Just to be very clear, there's a lot of detail in all of that, but a lot of detail is still to come, a lot of secondary legislation still to be produced. One of the key features of the bill is going to be the introduction of a character called the Building Safety Regulator to be part of the Health and Safety Executive and to underpin some of the proposed reforms. Two objectives for this body: first of all, to secure the safety of people in and around buildings, and second, to improve building standards. The functions of the regulator will include to implement a more stringent regulatory reform for high-risk buildings, to oversee the safety and performance of all buildings, including the development of new KPIs for building control, and generally to drive a greater degree of competence in the industry and amongst building inspectors and other professionals. The emphasis on high-risk buildings is the post-Grenfell legacy, particular emphasis in this regard. What is a high-risk building? Current definition is a building which is at least 18 meters in height, 7 stories, and also fits with a separate set of a description which complies with a separate set of regulations which were published alongside the bill, currently referred to as a building which includes at least the residential units, a care home or a hospital. A lot of debate at the moment as to whether the bill should just focus on that category. Bodies such as the ROBA making its point in its submissions to Parliament, fire doesn't discriminate, and there had been some degree of risk and concern that we might end up with a two-tier structure. The emphasis on high-risk buildings means that in terms of the design and construction of such buildings, there is to be a new duty holder regime, and under the framework which is to be introduced, this will be akin to the existing design, construction design and management regulations, where individuals involved in such a project would have particular responsibilities. And the other feature that was developed in the bill's proposal was the new planning gateways regime. There are to be 3 gateways, the first of which is actually already in effect, came into effect on the 1st of August 21, to submit an application for a high-risk building. It's necessary now to include a fire safety statement in a prescribed format signed by a competent person. And this will involve, in effect, the Health and Safety Executive becoming a statutory consultee before planning is granted. Gateway 2 will occur prior to construction work on such a building, and will involve an application to the Building Safety Regulator. With full design intent, construction cannot begin until the regulator is satisfied that the duty holder's design meets requirements, and there will be key information that will need to be submitted as part of the building control application to demonstrate how the building will address fire and structural safety. And Gateway 3 is effectively the completion final certification stage, when work on such building, the building is finished and the regulator assesses whether work has been carried out in accordance with the regulations. In effect, each of these gateways will be hard stops and introduce additional monitoring, and also inevitably will add to the time and costs involved. Next slide, please, Tom. The bill also addresses high-risk buildings in occupation. The bill provides for 2 new characters, an accountable person and a building safety manager. There's also going to be new obligations on the residents themselves. The job of the accountable person is to register a building within the scope of the new regime before it's occupied. If the building is already occupied, it will need to be registered within a transition period. And the accountable person is to apply to the regulator for a building assessment certificate, which will only be issued where it's clear that these statutory obligations have been complied with. The Building Safety Regulator is able to issue non-compliance notices where appropriate, and also there will be sanctions for non-compliance, which could give rise to criminal and other measures. Residents don't escape. Residents will be able to escalate concerns to the Building Safety Regulator, but residents themselves will also have legal obligations to comply, for example, with requests from the accountable person for information, not to act in a way that causes risk in regard to building safety, not to interfere with equipment that appears in common parts of a building, and to allow access to premises. One of the key points that came through from the Hackett inquiry was the need for more information. The golden thread of information, as it was called, defined by one review body as the golden thread, is both the information that allows you to understand a building and also the steps needed to keep both the building and the people safe now and into the future. And there are to be a set of golden thread regulations following 10 key principles, which will be produced. And it's thought very likely that this requirement is something that will spread well beyond the parameters of high-risk buildings. Some of the core controversial elements of the bill you probably would have heard something about. This includes the introduction of a building safety charge. In effect, this is how landlords and others will be able to recover costs for undertaking building safety related investigation and also works. This would apply under the current proposals anyway into what are called a relevant lease. A relevant lease is one which is granted for a fixed term of more than 7 years. A landlord will, under the provisions, be able to pass on the running and management costs of building safety to the tenant, in addition to the service charge. And this is one of the more controversial elements of the bill. And in regards to remediation works, landlords will have an ability to recover costs from tenants for the cost of the remediation work. There is a degree of limitation in that leaseholders will be able to require that a landlord takes reasonable steps to ascertain whether there may be other ways of recovering the cost of such work. So, for example, through a grant, or even possibly by action being taken against developers or others who might be responsible for that building. The prospect of that happening, of course, is going to be quite challenging, which is one of the reasons why there's a lot of lobbying at the moment for a completely different approach to this aspect of the legislation. The Polluter Pays Amendment is effectively looking at the whole principle of how these costs are paid for, akin to how you deal with environmental contamination. Broadly, under the amendment which is proposed, the government effectively would pay for the cost of the work and then turn and look to try and recover that cost from the industry. There's quite a bit of support for this bill to be introduced. We've yet to hear from Michael Gove, the new head of the relevant department, as to what he thinks. But broadly, the question is going to be whether you're going to continue to impose this cost on hard-pressed occupants of these sorts of building. In terms of regulatory enforcement, there will be new powers to increase the periods within which action can be undertaken, and also the scope of penalties and fines that can be applied. And that will be led by the building regulator, but with enhanced powers under the existing Building Act. And one of the more interesting elements of the bill, which got a bit of a headline when it was first introduced, is the proposal to extend the powers of individuals to bring action under the Defective Premises Act. The Defective Premises Act establishes a duty of care in regard to any person who's undertaking any work in regard to a dwelling. Builders, construction professionals, and others. The duty is owed to whoever takes an interest in such a dwelling to see that work undertaken is done in a work-like manner with proper materials, and so that the work, when completed, will be fit for habitation. These specific proposals include to extend not only the scope of the Act to cover refurbishment work or remedial work, but also to extend the time periods within which a claim can be made from the current 6 years to 15, and to make that ability retrospective. Quite a bit of discussion at the moment as to whether 15 years is going to be enough. Quite a bit of talk about that 15 years becoming 25 years, so watch this space. Other changes in that regard include to introduce Section 38 of the Building Act, which currently has not been enacted, which will give a civil right to bring an action for non-compliance with the building regulations. I'm coming up close to my time. Other proposals include to reform the building control system with a registration regime for professionals, building inspectors, and also building control approvers. And next slide, please, Tom. And beyond that, a very significant element will be to look at the labelling and the registration of building products. Currently, we're still operating under the EU-based regime. Under what is proposed, there will be an entirely new construction products register, with safety critical products being placed onto a statutory list, and new civil penalties and criminal offences to be enforced by trading standards. Next slide, please, Tom. I'm coming close to the end of my slot. And also architects are in the firing line. There will be new powers for the Architects Registration Board in regards to the monitoring of registered architects, and architects will also be required, unlike now, to go through continuing professional development throughout their career. New competent standards are to be set, and for those architects guilty of misconduct or serious professional incompetence, there's the risk of being deregistered. Next slide, please, Tom. And for owners of new buildings, there is the proposal for the new Homes Ombudsman. New build home owners will be able to escalate their complaints to this new body. Funding for the body will be developed under the bill. In effect, this will be a quality management scheme to which all developers will be expected to sign up. Next slide, please, Tom. And finally, the timetable for all this. Well, currently the timetable is for the first stage of the bill to be enacted at the end of the summer of 22, and for the rest of the elements of the bill to come into effect over time. This is a huge piece of legislation. A lot, though, could change from what we currently see. Anyway, that's my canter through. We will continue to pump out information about the bill as it develops. Thanks, Keith.